Hello everyone and welcome to today's Mondac webinar in association with Shareholders Partners, who will be discussing what you need to know about the PRC new company law. My name is Dan Sampaio and I'm joined by a brilliant speaker to take us through today's discussion. Yulong Lai specialises in commercial dispute resolution and acts for well-known multinational corporations in commercial disputes before various levels of courts across China. He has extensive experience in handling arbitration cases administered by CTAC, BAC, SCIA, Guangzhou Arbitration Commission, HKIAC, SIAC, SCC, and arbitration cases under the UNCITRAL arbitration rules. He is an arbitrator of the Shenzhen Court of International Arbitration Jiangmen Arbitration Commission, and a mediator of the Qinghai International Commercial Mediation Center. He was listed in the Rising Star list by China Business Law Journal and one of the top 30 outstanding rising stars by Legal Band. Now, before we begin today's webinar, a quick housekeeping item. You can submit questions to Yulong by typing them into the questions pane of the toolbar on the right-hand side of your page, and we will endeavor to answer as many questions as possible during our Q&A session, but please do reach out afterwards for any additional information you may require. It's now my pleasure to hand you over to Yulong to begin today's session. Thank you.
Thank you, Dan, for the introduction, and Mondac for organizing tonight's webinar. Hello, everyone. First of all, thank you all for joining today's session. My name is Yulong, and I'm currently a partner at Shareholders Partners in our Shenzhen office. Thank you all for your time today. I know it's different time zones. It's probably early morning in the United States and maybe nap time in Europe. And I'm supposed to be at home making up stories to put my kid to bed. But I'm glad to have tonight off and share with you some updates about the newly revised Chinese company law. As Dan says, if you have any questions, you can submit to us, and I'll try to answer to the best I can. And if the time is running late tonight, you can always send me an email. I have put my email address here, or here's a QR code if you use WeChat. We can discuss after this webinar. Also, we have prepared an English translation of the new company law, and I'll check with the Mondac team to see how to share with you after tonight. Okay, so tonight's topic is about what you need to know about the new PRC company law. First, let's take a look at the developments of the PRC company law. We published our very first company law and established the company law regime back in 1993. It's a very young law as compared to the very established common law system. And there have been a few revisions or modifications over the years. In 1999, 2004, 2013, 2018, and the latest revisions happens in late 2023. The new company law, which will come into effect in less than 3 weeks, which is now coming very close, starting from July the 1st, 2024. We can say it's arguably the most significant amendment in the history of the Chinese company law history. As you can see from the slide, I put some statistics here. The new company law now consists of 266 articles. In this, it deletes 16 provisions from the 2018 version, and compared to the 2018 versions, it adds or revises 228 articles, and among which 112 involve substantive amendments. So you can see this is a rather comprehensive revision, and I would say the most significant one. The time today may be limited, but I'll walk you through. I can't walk you through all 266 articles, but I'll walk you through some of the major amendments. Today, I will cover the amendments in these 4 aspects. First, the capital contribution. Second, in terms of the shareholders' rights. And third, in terms of senior management's liability. And fourth, in terms of the corporate governance. The very first major revisions will be in the capital contribution. The new company law adopts a new capital contribution requirements as compared to the previous versions. Let's go back a little bit first before we go into the new law. In the 2013 revisions, we actually lifted the minimum registered capital requirements from the law, and also we lifted the time period for shareholders to make their capital contributions. I understand one of the purpose of this reform was intended to stimulate investment. However, in practice, we do see a lot of concerns and problems arising from this system. For example, if you have ever done business with Chinese companies before, you may see some Chinese companies with very high registered capital. This company may just be operating a small export and import business, but it may have a registered capital of over several million or even billions of Chinese yuan. And this is not uncommon. On this slide, I randomly looked up a company and put here a company with a very highly inflated registered capital. As you can see, there are 1, 2, 3, 4, 5, 6, 7, 8 nines, and the unit is 1,000 euros. These companies look like they are financially very strong and big companies, but in fact their liquidity are usually doubtful because this registered capital does not truly or correctly reflect the financial status of this company. Also, in terms of the contribution period, you can also see many companies provide for a very long time in the Articles of Association. The contribution period can be as long as 100 years or even much longer in practice. For example, here, I put a company here established in 2016, but the capital contribution is not until 2064, which is 50 years after this company is established. So the past system brings a lot of troubles and problems in practice. Therefore, the very first major change in this revision is a change in the direction in terms of capital contribution. And now we adopt what we call a time-limited capital commitment system. Let's see Article 47 of the new company law. According to Article 47 of the new company law, the total amount of capital subscribed for by all shareholders shall be paid in full within 5 years from the date of the company's incorporation. And the same rule should also apply to capital increase according to Article 228 of the new company law. This is the legal provision. It changes the time limit of capital commitment restrained within 5 years. So the very first question our clients have been asking in the past few months, whether they are domestic company or foreign investor, is how this would apply to companies established before July the 1st, 2024. And these companies, they originally provided for a capital contribution period longer than 5 years. So let's see Article 266 of the new company law, which is literally the last provision in this law. According to Article 266, this law come into force, as I said before, on July the 1st, 2024. And for companies already registered for incorporation before this law enters into force, if their capital contribution period exceeds the period stipulated in this law, they shall gradually adjust to the period specified in this law. And in cases where the contribution period or amounts are significantly abnormal, the company registration authority may require timely adjustments. So there are two takeaways. One, the contribution period shall be gradually adjusted. It's not saying that there is a line that the companies registered before the new law applies the old rule. It is saying that all companies shall be adjusted to the new rule. But of course, the specific implementation rules are yet to publish by the State Council. There are documents flying around these days, but still the official implementation rules have yet to publish. So there is no clear answer of how this transition will take place. And second, if you don't adjust, then the company registration authority may find a way to take initiatives to require you to adjust. This also remains to be tested how this will be implemented in practice, because there are just so many active registered companies in China. I believe the company numbers should be over 40 million all over, registered all over in China. It's just impractical for the company registration authority to take initiatives to go through all these companies. But we'll see how this transition period work out after the State Council issue the implementation rules, which we believe will happen in the upcoming month. So this is the first major change of in terms of the capital contribution, a 5-year contribution period. And a related amendment to the capital contribution is when there is a transfer of equity, how to allocate the liability regarding the unpaid registered capital between the seller and the buyer, or we say the transferor or the transferee. This is an obvious question, because when you transfer the equity, it is common that you have not yet paid up the capital contribution because your contribution period is not due yet. In the current judicial practice, there are mixed judgments. Some courts would rule that the buyer shall be held responsible for the capital contribution. Some hold that the seller should be responsible. Some rule for the buyer or the seller to take complementary liability, and some rule for them both to take joint and several liability. There are just different kinds of judgments in practice. But now the new company law provides a clear set of rules in Article 88. First, according to paragraph 1 of Article 88, as you can see in the slide, for transfer of equity that has been subscribed for, but the deadline has not yet been reached, the transferee, or we say the buyer, shall be responsible for the capital contribution. Meaning that if you are a buyer and you are buying shares or equity from a seller whose capital contribution period has not yet been reached, then you as the buyer shall be responsible for the capital contribution afterwards. But if the buyer does not pay in full on time, then the seller bears a supplementary liability. The new law adopts the position that the buyer is, or the transferee is, the primary person responsible for paying the capital. But if it fails to do so, the transferor or the seller shall bear supplementary liability. As comparison, in the second case, where a transferor or a seller or a shareholder transfer its equity that has already been overdue but not paid, or if the value of his non-monetary contribution made by the seller is significantly lower than the subscribed capital, then the buyer will be held jointly and severally liable with the seller. Meaning that if you are a seller and you are transferring equity that has already been overdue, but you have not paid the capital contribution in full, then the buyer shall be it shall be held jointly and severally liable with you for the shortfall. And the second circumstance is where the value of the non-monetary contribution, meaning that sometimes you pay not by cash, but you pay, for example, through intellectual property. If there is a shortfall, then the buyer shall also be held liable with the seller together. However, there is a defense for the buyer. If he can prove that he is unaware of or should not have been aware of this situation during the transaction, then he can be free of the liability. So this, what are the implications for this new rule in terms of transfer of equity, in terms of capital contribution in transfer of equity? It's obvious that it calls for more careful drafting and appropriate due diligence when we are buying or transferring equity. For example, if you are the seller, it is always advisable to put that the buyer acknowledges that it should bear the capital contribution obligations. And if the buyer fails to do so afterwards, then the seller, if the seller is requested to bear a supplementary obligation, then the seller should ask for compensation from the buyer. And if you are the buyer, then of course you should thoroughly investigate the capital contribution status of the equity during due diligence in the transactions. And you should make appropriate arrangements in the agreement to reflect this capital contribution status. For example, you may want to include reps and warranties that the seller has completed in full its capital contribution obligation. There are other topics in capital contribution, but I'll not go into details tonight. For example, in the new company law, if a shareholder fails to contribute its capital on time, the company may issue a written notice to forfeit his equity. And the capital contribution period can be accelerated or matured before the contribution period expires in some cases. For example, if the company is unable to repay its debts. Overall, in capital contribution part, the new company law applies a stricter set of rules to regulate the company's capital contribution, with an aim to correctly let this capital contribution correctly reflect the company's actual financial capabilities, rather than deviate from the company's actual operating capabilities. So this is the first part I would touch upon. It's the capital contribution. And the second part would be shareholders' right protection. In this part, the main change or direction in the new company law is the enhanced protection of the shareholders' rights. Especially when we are saying shareholders' rights protection, it's especially the protection of minority shareholders' rights. The first thing we will look at is the expansion in the shareholders' inspection rights, or what we would say sometimes right to information. Specifically, there are expansions in three aspects, as you can see from the slides. An expansion in the scope of documents examined, an expansion to the subject of information right to wholly owned subsidiary, and expansion to joint stock companies. So first, as a general rule, under the company law, shareholders, I think it's universal, shareholders are entitled to information rights to inspect the financial audit reports and accounting books of a company. But in practice, a very commonly seen dispute is whether shareholders are entitled to examine the underlying accounting documents. The current company law only grants for the access to the accounting books, but not the access to the accounting documents. I'm not an accounting expert, but my layman understanding is that accounting documents are the basis for making the accounting books. For example, the accounting documents may include the underlying contracts, the orders, the payment requests, and the payment slips, etc. So in the current judicial practice, this is a highly disputed issue, whether shareholders are entitled to the underlying accounting documents. The newly amended company law makes it clear that the financial inspection rights of shareholders does extend and include access to the company's accounting documents, as you can see from Article 57 of the new company law. Shareholders may request to inspect the company's accounting books and vouchers or accounting documents. This is a translation issue because I'm not sure what's the more precise or accurate translation of this accounting documents. Some translation may translate this into vouchers. So this accounting documents, we believe it's always can always more truly reflect the company's financial status. So in this aspect, the amended law in this actually expands the scope of financial information rights and protect the shareholders' rights in this aspect. And the second extension is the target of the inspection rights. This is a totally new thing. Under the new Article 57, the same inspection rights I mentioned before can be extended to the company's wholly owned subsidiaries, meaning that if you are a shareholder of a company, you are not only entitled to review the accounting books and accounting documents, audit reports, financial documents of this company, but you are also entitled to the same scope of information rights to the company's wholly owned subsidiaries. This is a new thing, and this is another example of the enhanced protection of minority shareholders' rights under the new company law. And the third expansion goes to joint stock companies. This is, I would say, it's rather a makeup for the previous law. There's no explicit, it's odd that there's no explicit provision in the current company law about the same inspection rights in terms of joint stock companies. But in the new company law, it is now clearly stipulated that shareholders holding 3% or more of the company's shares for 180 or more consecutive days are entitled to the same inspection rights to the company's accounting books and accounting documents. There are also other provisions in the new law about the inspection rights that I didn't put it here. For example, shareholders may engage professional third parties, such as accounting firms or lawyers, to facilitate and help them with this exercise of information rights. So the first aspect of this shareholders' right protection is about the information right. And the second amendment we would look into in terms of minority shareholders' protection is Article 89 of the new company law, about how dissenting or oppressed shareholders can request to repurchase the company, can request the company to repurchase their shares and seek for an out of the company. On the left side, you can see this is the old provision under the current company law, Article 74. According to Article 74, a shareholder can request the company to repurchase its equity in certain circumstances, which is which are mainly three circumstances. First, if the company has not distributed profits to shareholders for 5 consecutive years, and the company has been profitable in these 5 years. And second, in the event of a merger, division, or transfer of principal assets by the company. And three, if the business term specified in the company's articles of association has already expired, but the shareholders meeting still passed a resolution to amend the articles of association to continue the company's existence. Then in these three circumstances, a dissenting shareholder can ask the company to purchase its equity at a reasonable price. However, this provision is actually not oftenly used or relied upon in practice, because one, the circumstances where you can ask for or request a repurchase is very limited. And second, it's as you can see in Article 74, there is a prerequisite that the shareholder should first be voting against these resolutions at the shareholders' meetings. But in practice, many of the times, the minority shareholders or dissenting shareholders, they were not even notified of the shareholders' meetings. So they are actually not dissenting shareholders. They are ignorant shareholders. They don't know anything, let alone they vote against this shareholders resolution. So without this act of voting against the resolution, Article 74 does not apply because the prerequisite is not met. This is the dilemma we faced in judicial practice. But now in the new company law, we add a new provision right after this Article 74 as a paragraph 2, granting shareholders the right to demand repurchase of shares by the company if the controlling shareholder abuses their shareholders' rights. So basically, the first part is the same, and the second part is the newly added one, and it's a separate paragraph. I view this provision as a safeguard clause to protect minority shareholders' rights in all other circumstances. The conditions and prerequisites I mentioned earlier about voting against the resolution does not apply in this provision. According to the new Article 89, paragraph 2, as long as you can prove that the controlling shareholder of the company has abused its shareholders' rights and caused serious damage to the interests of the company or other shareholders, then as shareholders, you have the right to request the company to repurchase your equity at a reasonable price. I personally, as a litigation lawyer, I anticipate this provision will be used very often in the future. This can be a very useful weapon for what we say oppressed shareholders or minority shareholders to seek for an out in a company. Because in the past, if you are a minority shareholder, you don't have much you can do. But now this provision leaves much room for you to argue. As long as you can prove that, you only need to prove, not as long as, you only need to prove that the controlling shareholder abused their rights and caused damages to you or the company. As you can see, this provision, there is much room for courts to interpret in individual cases or to examine in individual cases to determine what abuses rights and causes harms would mean. Here I listed some circumstances which I think may fall under this provision. And again, as I said, there is no clear-cut standard of how you should prove there is an abuse and there is a serious harm. This is more like a case-by-case scenario. So this is why the reason why I say it can be a very helpful or powerful weapon for minority shareholders. For example, if the controlling shareholder is transferring the company's main assets to other related entities at a unreasonably low price, or purchasing assets at a unreasonably high price, then you may argue that they are abusing their shareholders' rights and harming the interests of the company. Or if they constantly exclude you as a minority shareholder to participate in any of the company's corporate governance activities, you can also argue that this is an abuse of their controlling shareholders' rights and cause serious harm to you. There are just so many circumstances that you can rely on, and that's why we don't have a provision listing out all the circumstances here, but more as a open-ended clause for you to rely upon, for oppressed shareholders to rely upon. So in the second part, we look at the shareholders' rights, the enhanced protection of minority shareholders' rights in two aspects. One is the right to information, and the other is a remedy to seek out when you are like abused by the majority shareholder. And next, let's see. Next, we'll take a look at the third aspect of this new company law amendment about the stricter. I phrase this as stricter liability for senior management. By senior management, we are usually referring to directors, supervisors, and senior management. And under the new company law, this may sometimes extend to controlling shareholder or actual owner of the company, which I'll explain later. And this is why I'm saying the new company law now imposes a higher and stricter duties and responsibilities on senior management. First, let's take a look at the definitions. I put many articles here because I'll ask the Mondac team to share the slides with you after tonight's webinar, and I put many things on here just for your easy reference. Let's first take a look at the definitions. We do have in our company law, we do have fiduciary duty and duty of diligence in the current company law, but it is a very general provision. It only says that directors, supervisors, and senior management own a fiduciary duty and duty of diligence to the company. There is no elaboration or definition of this fiduciary duty or duty of diligence. So in this new amendment of the company law, for the first time, we introduce definitions to clarify these two concepts and the general scope. Let's take a look at Article 180. About our paragraph 1, it's about fiduciary duty, or what we also call duty of loyalty. It's just different translation. Article 180 of the new company law defines fiduciary duty in two aspects. One, avoid conflicts between directors' own interests and the interests of the company. And two, they shall not use directors' power to seek improper interests or improper benefits. As for duty of diligence or duty of care, different translation again, Paragraph 2 of Article 180 provides that directors, supervisors, and senior executives shall exercise the usual and reasonable care that a manager should have for the maximum benefit of the company. So these are the two basic definitions of the fiduciary duty and duty of diligence. And other than these two definitions, the new law also further elaborates on the scope of fiduciary duty in from Articles 181 to Article 184. Specifically, Article 182 regulates self-dealing and connected transactions. Article 183 regulates exploitation of corporate opportunities. Article 184 regulates operating competing business. I put up a chart here, but for your easy understanding, I think there are a few changes in these provisions that are worth noting. First, under the new law, the shareholders meeting is no longer the only proper level of internal corporate governance body to grant approval in these conflict matters. Instead, a company may now stipulate in its own articles of association about the approval property. A company may stipulate in its articles of association about the approval authority for these conflict matters. For example, connected transactions, seeking of business opportunities of the company, and engaging in similar business. Which means that you can provide in your articles of association whether this issue goes to the board of directors or go to the shareholders meetings. This change also reflects one of the new company law's revision in that it is putting more power in the board of directors instead of the shareholders meeting. So this is the first change I'd like to share. And the second one is Article 185. As you can see, it's during the decision making and the voting process. If this matter goes to the board of directors, the new company law provides that the interested director of this conflict matters shall abstain from voting in this matters. Their voting rights shall not be counted in the total voting rights. And if the number of directors if the number of unrelated directors are less than 3 directors, then this matter shall be submitted to the shareholders meetings for deliberation. And the third new change I would bring to your attention is Article 183. In the past, there is no exemption for the prohibition of seeking business opportunities of a company. But now there is an exemption, as you can see in the second, in paragraph 2 of Article 183. If the company itself is unable to take this business, specifically to take this business opportunity according to the laws or other regulations, then the senior management, or we say directors, supervisors, and senior executives, they are entitled or permitted to pursue these business opportunities without seeking the approval from the board or the shareholders meetings. Because in this case, the company just is unable to take the business, so there is no conflict at all. These are the 3 changes I would like to point out. And of course, as you can see from the the most right column, for the consequence of the breach of fiduciary duty other than the compensatory obligation, Article 186 also provides that all income derived from such breach of fiduciary duty shall be attributed to the company. This is the first aspect we are saying about the fiduciary duty of the senior management. And as I touched upon before, the stricter why we are saying there is a stricter liability, we can also it also reflected in the new company law, in that there is an extension of the persons liable for fiduciary duty and duty of diligence. The first group of people we can see is it may extend to a controlling shareholder or actual owner or controller of the company. According to paragraph 3 of Article 180, the fiduciary duty and duty of diligence shall apply to the controlling shareholder or actual controller of a company who does not serve as a director, but actually executes the affairs of the company. This is what we say in Chinese de facto directors. They are not officially appointed or registered as directors, but in fact, they are managing the business of the company. Then they will have the same statutory fiduciary duties as a director. This is the first extension, the fiduciary duty extending to the controlling shareholder or actual controller. The second extension is to shadow director. According to Article 192, where any controlling shareholder or actual controller of a company instructs a director or senior executive to carry out any act damaging the interests of the company or the shareholders, it shall bear joint and several liability with that director or senior executive. This is also a new provision about shadow director. Shadow director regulates those controlling shareholders or actual controllers who exercise their management powers by instructing the directors or senior management to act at their will. So this is the second the second aspect I mentioned about extension of the fiduciary duty. And the third aspect is the extension to directors, supervisors, or senior management of the wholly owned subsidiary. According to Article 189, a shareholder is entitled to have the right to file a lawsuit against the directors, supervisors, and senior management of a company's wholly owned subsidiaries. So this is another dimension of extension. The fiduciary duty can be extended to the subsidiaries' senior management. So as I said, now the new company law is applying a stricter duty and liability on the either directors or senior management, or even on the controlling shareholders. So in practice, if we are directors or senior management of the company, of course, it is always advisable to exercise with extra care to avoid this civil or administrative liabilities. And also we have insurance for directors, for senior management. And as shareholders, if we are only acting as shareholders, there should be clear protocols there should be clear line in exercising your shareholders' rights in the companies you invested, and exercising excessive rights to interrupt the operating of the companies you invested. This is what I would take away from this stricter liability on or stricter fiduciary duty and duty of diligence. the next page, I list out this is another aspect to look at the stricter liability of directors. The new company law imposes a strict liability or a very high duty on senior company officers in terms of maintaining the company's capital adequacy. These are some of the provisions where the senior the company's senior management or directors will be held responsible for the compensation if the company's capital fell under the appropriate level. For example, according to Article 51, directors actually have the obligation to send notice to shareholders who have not paid their capital to call for their capital contribution. And if the directors fail to fulfill this obligation and cause damages to the company, then the responsible director may be held liable for compensation. There are other provisions in different parts of the new law that impose duty on senior management in terms of maintaining the company's capital adequacy. I will not go into details, and I'll leave the slides to you. I think the time is running up, but I want to leave a few minutes to answer some questions, so I'll quickly go through the last part. The last part is about corporate governance. I use a streamlined corporate governance because in terms of the corporate governance, I would say, although there are many revisions here and there, I would say there's not much substantive change that would completely blow your mind. So I'll point out some changes I find worth noting. For example, the second part, Article 66, paragraph 2. The new law provides that the shareholders' resolution shall be adopted with at least a majority of the voting right, meaning that shareholders' resolutions can only be passed with a voting representing more than 50%. You may find it odd because in the current company law, there is no such requirement. Companies may decide itself about the minimum requirements or the requirements for an effective resolution. For example, we can agree that we can pass a resolution with 30% of voting rights. There is no such requirement in the current company law, but in the new company law, it adds a 50% requirement. And Article employee director. This is also one of the commonly asked questions we face from the client. Article 68 provides that for a limited liability company, which is the most commonly seen company form, and most of the provisions I mentioned previously is about limited liability company. If a company has more than 300 employees, then it is required to include employee representative in its board of directors, meaning that if you're a company with more than 300 employees in your board, you should have at least one board director who is an employee representative. This is many of our clients are asking us because many of our clients have more than 300 employees in China. They're asking how to implement this. And our advice is to wait because there is no, the specific implementation rules have not been issued yet. And the consequences for failure to do so has not been tested yet either. So we are waiting for further clarifications or implementation rules from the State Council to see how to actually put this in practice, because companies, they don't want to put employee representative in their board of directors. So this is also one of the areas that we remain to be seen how to implement. And Article 73 adds a new statutory quorum for board meetings, which you may find it odd as well that we don't have it in our current company law. The meeting of board of directors shall only be held with the presence of a majority over 50% of the directors, and any resolution as the shareholders meeting, any resolution of the board of directors shall be made by a majority of all the directors. Article 69, it's a new thing. There's a new thing called the audit committee. This is the new thing introduced in this company law revision. Audit committee is established under or within the board of directors, and if you form an audit committee, then you can choose it, and then you can choose not to establish a board of supervisors. Article 69 is saying that a limited liability company may establish an audit committee within the board of directors, composed of directors, to exercise functions and powers prescribed for the board of supervisors by this law, instead of establishing a board of supervisors or appointing a supervisor. This is because the board of supervisors is actually not working very well in the current company law regime. They have limited power, and they are usually just there because the company law requests a supervisor. This supervisor, they have no or limited corporate governance functions in practice. But now, with the setup of this audit committee under the board of directors, this new mechanism may strengthen the internal financial supervision over the companies. But again, how to establish this audit committee, or who should decide the selection of the audit committee, this is also controversial and left open. It's an open question now, because the law does not specifically provide for the implementation rules. We are anticipating that the new implementation rule associated with the new company law, which will be issued and published by the State Council, will have further provisions or guidance on this composition of the audit committee. So, the last thing is Article 24. It's against the backdrop of this technology development, and also the pandemic. So now the meetings of shareholders, board of directors, or board of supervisors can be conducted through electronic communication methods. This is now put into the law, as compared to the current law is silent. The current law is silent on this. So just to recap, today we cover 4 aspects of the new company law. The first one is the new capital contribution requirements. We now apply a 5-year contribution period and a stricter contribution requirements aiming to correctly reflect the company's actual financial capabilities and actual financial status. And the second aspect is for shareholders, especially minority shareholders. We have added many protection measures to protect minority shareholders from being abused by the majority shareholders. For example, granting them more access rights to information, and granting them ways to seek for out of the company. And the third one is the new law applies a stricter liability, either in terms of fiduciary duty or in terms of the duty of care or duty of diligence on senior management, mainly directors, supervisors, and senior management. And sometimes this may be extended to controlling shareholders or actual controller, which is why now there is a stricter duty and liability on the company's management. And the last part is about some changes in the corporate governance. This also would require some changes in the articles of association and the daily company operation. And but the specific rules, many of the items remains to be tested or remains to be guided in the specific implementation rules. So basically, that's how that's all I want to share with you today, and hope this sharing is helpful to you. And if you have any questions, because the time is limited, we can't go into every details of the new company law. But if you have any questions, you can always feel free to shoot me an email and we can discuss further. Now let me take a look at some of the questions in the chat box. Okay, let me see. Okay, so the first question is, where a subsidiary company becomes bankrupt, can the parent company be liable to the creditors? So I think this is the general principle is the same under PRC law, like all other common law jurisdictions, that each company is separate in terms of its own assets and in terms of its own, we say, identity. So as long as there is the general principle is no, the shareholder is only responsible for its capital contribution to the company. The shareholder will not be held liable for excessive for excessive obligations other than its capital contribution. But there are exceptions, of course. For example, if you withdraw your capital contribution from the company, then you may be held liable for the compensation to the creditors. And also there is another circumstance under PRC law. If you are a 100% shareholder of a company, and if you cannot prove that your financial or your financial operating is independent of this subsidiary, meaning that it's just piercing the corporate veil under the common law. If you cannot prove that these two entities are independent entities, meaning that if you don't have audit reports for each companies during each financial years, then as the sole shareholder of this company, you may be held liable for the subsidiaries' debts other than your capital contribution obligation. So I would say the general principle is that you are only liable for your contribution part, but if there are certain violations of you exercising your shareholders' rights, then you may be held liable for more obligations. Let's see. The second question. If
You long, I think that we may have lost you there. I'll give it 10 or 20 seconds to see if we can get you back and get the question answered.
I'm not sure whether you can still hear me now. So
We can see you and hear you again, Yulong. Thank you very much.
okay, so the live stream is off, or should I continue to answer the last question? I don't know.
Please do answer the last question, Yulong. Thank you.
Okay, cool. The question is if a company changes its main industry from real estate to manufacturing and consultancy, is there any implication? I'm not sure because in China, each company is required to register its business scope with the company registration authority. You need to file to the company registration authority saying that, for example, my company is in export and import business, then you have to write it on your business license, and this is shown as a public information. And of course, you can change your business scope. For example, tomorrow I want to do in the food industry, then you have to apply to the change to the company registration authority for the change. I'm not sure what implication we can see from this change, but in certain service, you need to obtain certain license. For example, as I said, if I want to change into the food industry, then I may have to obtain some license and permit from the Food and Health Bureau. So I would say it's not uncommon for a company to change its business scope, but if the change is very dramatic, for example, from real estate to consultancy, then I would say it's abnormal. But this mere change, I don't think it has any specific implications. But we will need to look into more about the company's files to see, and also public information about these companies to see why there is a change and whether there are other implications behind this change. Yes, I think we have run out of time, so I will leave the floor back to Dan. And thank you all tonight this morning or this afternoon, whatever, for your time. And hope this session is helpful to you. And let's keep in touch.
Thank you so much, Yulong, for your time. I know it's very late where you are, so we really appreciate you staying with us and imparting such knowledge. It was an incredibly thorough and insightful session for us, so we really appreciate that, Yulong. We hope that we can see you again soon for another session. To our audience, thank you very much for being with us, and thank you for the questions that were sent in as well. As Yulong mentioned, you will receive a copy of the PowerPoint slides after this session. So all that's left for me to do is wish you all a lovely rest of your day. Yulong, thank you once again. Hope to see you again soon. Goodbye, everyone.
Bye.